A 2015 High Court case, the RC and Myriad genetics, focused on whether an isolated nucleic acid coding for a mutant or polymorphic BRCA1 polypeptide was, as the respondent held, a patentable invention within the meaning of Section 18(1) of the Patents Act with regard to manner of manufacture within Section 6 of the Statute of Monopolies. It also focused on whether there was an artificially created state of affairs which produced an economically useful result. The presence of BRCA1 indicates mutations which place women at a high genetic risk of developing breast cancer and ovarian cancer. The majority held that the substance of the patent was information embodied in the arrangement of nucleotides. This information was not made by human action, it was discerned. The High Court held unanimously that the BRCA1 patent was not valid as it did not fall within the definition of a manner of manufacture of Section 6 of the Statute of Monopolies. The High Court also gave regard to the patentability of a gene or genetic material should be something for the legislative to consider or expand on, and any significance of international obligations like TRIPS should be for their consideration. Myriad's decision means that patents relating to genetic material may be challenged and further applications will likely be denied. Myriad has been applied in regard to cases not concerning genes already. In Commissioner of Patents and RPL Central, the court's interpretation of what consisted of a manner of manufacture was implied in respect to a computer program. Throughout Myriad, the High Court had regard to the chilling implications that gene patents could have on the research and development of genetic testing and the potentially negative effects on innovation. Throughout, it was raised that someone extracting genes and testing them without any purpose related to BRCA1 would be in breach of the patent if they extracted the nucleotides which code for BRCA1, which is something that would be unknown until after the extraction process. There was no way to prevent someone from accidentally breaching the patent. It also emphasized that the process for extracting BRCA1 is not new or patented or unknown in the research and development. Attention surrounding the case was drawn to the parallels of Myriad's conducting of BRCA1 testing in the United States, where the cost of testing is significantly high and can in some cases prevent women from being able to partake in the tests and thus, in reality, limit their exposure to healthcare. In the American case, Association for Molecular Pathology and Myriad Genetics, the Supreme Court held that the BRCA1 patent was invalid. Myriad operates through Genetic Technologies in Australia, which has stated it would not enforce its patent in Australia for public laboratories through which testing would have been subsidised anyway. The Australian Law Reform Commission has in the past refused to acknowledge that gene patents have an impact on the cost of healthcare. An impact the Cancer Council Australia says reduces public access to genetic technology and cancer control and increases the cost of genetic technology for both government and community. Gene patents in some situations can result in higher healthcare costs, especially when the biotechnology company is the only avenue for the testing. But they also represent an incentive for companies to invest in medical research industries and provide protection for the owner of the patent. Whether Myriad's case will affect the medical research industry cannot be discerned this early.